Committee has ruled out the possibility of a multiple question referendum as proposed by a section of BBI opposes. But even as the possibility of having a referendum still remains uncertain, with the Independent Electoral and Boundaries Commission IEBC Chairman Wafula Chebukati holding that the proposed 70 constituencies will take at least 2 years to create, the committee in its report has termed the 6-month timeline proposal for the creation of the constituencies unconstitutional. Here is our reporter Musa Salah with a comprehensive analysis of the committee's report.
The Joint Justice and Legal Affairs Committee, JLAC of the Senate and the National Assembly, handed over its report to Senate Speaker Ken Lusaka, paving way for the bicameral parliament to debate the Constitutional Amendment Bill 2020 before the bill is rolled out for a public vote. According to the committee, the BBI bill will be subject to a referendum pursuant to Article 255(1) and Article 257(10) of the Constitution, which require an amendment to the Constitution through a popular initiative be done through a referendum. The committee has also ruled out the possibility of having a multiple question vote, claiming that although the BBI bill deals with multiple issues, the issues in the bill are interrelated. The committee further notes that it will be impractical to ask Kenyans to vote on multiple questions. However, the latest bone of contention in the August House is the introduction of 70 new constituencies. According to the committee, the proposal to distribute the proposed 70 new constituencies among 20 counties is unconstitutional and only seeks to usurp the powers of the Independent Electoral and Boundaries Commission IEBC. IEBC Chairman Wafula Chebukati told the committee that the creation of the constituencies would take at least 2 years, rubbishing the BBI proponents' plan to have the constituencies in 6 months if the popular initiative passes, totaling the number of elective constituencies to 360.
During the first delimitation under the Constitution of Kenya 2010, the Interim Independent Boundaries Review Commission undertook data collection and first round of public hearings from May 2009 to November 2010.
Under Article 89 of the criteria for representation, which is by population, that ideally would have put a competent commission under notice that you needed to do some work on the question of delimitation.
According to Article 89(4) of the Constitution, if a general election is held within 12 months after the completion of a review by the IEBC, the new boundaries shall not take effect for the purposes of that election. In its report, the JLAC committee knows that the attempt to oust the application of Article 89(4) of the Constitution in the delimitation of the 70 constituencies as proposed in the BBI bill will only be possible if Article 89(4) was expressly amended. The committee further notes that this would create parallel and conflicting mandates to review the new boundaries. However, there are dissenting voices within the JLAC committee, with the committee members Senators Johnson Sakaja and Rungu Kangata holding a minority position on the matter. According to Sakaja, Parliament has no justification to oust the BBI proposal to have the new constituencies within 6 months on grounds of legal technicalities.
Every schedule to any legal instrument, whether a constitution or a statute, must have specific clauses in the substantive law explaining and justify the inclusion of a schedule. You cannot insert a schedule to a statute or any legal instrument without some explanatory notes on the substantive part of a piece of legislation, whether it's a treaty, whether it's a constitution, whether it's a statute.
Okay, thank you.
Musa Salah, TV 47.